now have questions from committee member. Mr. Monty.
Thank you, Mr. Chair. I just want to start by thanking all of you for your respective service and particularly advocacy, protecting victims' rights. I think you'll find unanimity among us, although we may disagree on our analysis of the ballot measure. I did want to just ask, I heard from a couple of speakers a statement that there's not a belief that the death penalty serves as a deterrent. Is that a fair sense of the view of others?
I don't believe any of us said that.
I thought I heard.
Certainly not my view.
I thought I heard a reference from.
Yeah, Mark Peterson, District Attorney. I don't have any statistical or study that would convince me that it serves as a deterrent. I have heard anecdotal reports from individuals. I happen to believe in the death penalty because I believe that there are certain crimes so heinous that they deserve the death penalty. So my personal support of the death penalty is not based on a deterrence. It's more that the crime warrants that punishment.
Right. And I think one answer to that, and Mr. Scheider, I'm going to give you an opportunity, but I think one of your stronger arguments does go to the question of the use in plea bargaining as leverage in securing a confession of guilt. But in other words, as I understood it, if a death penalty is a possible charging or sentencing option that an accused, let's say a guilty accused, faces in pondering those choices, they're more likely to offer a guilty plea for life without possibility of parole, as I understood it. But on that issue, would you agree that there could be a circumstance of an innocent defendant who, given that choice and fearful of not receiving justice, would make the choice of a confession to preserve life as opposed to going into the uncertainty of a death penalty conviction?
I can't imagine pleading guilty and accepting life without parole if I was actually innocent. I mean, that to me is just an inconceivable thing that anybody would do.
Well, we have heard some statistics from studies of a number of cases around the country where innocents were convicted and sentenced to either life without possibility of parole or death penalty.
The 4% number you heard earlier is a extremely controversial and very much criticized study. The person who did that study is a dyed-in-the-wool opponent of the death penalty, and his work is extremely controversial. So I definitely would not accept that as a given.
Would you agree that there's been any people wrongfully convicted to the death penalty?
There are a few cases, far less than the number you heard. The DPIC list is not a list of innocent people. But there are a few cases where people have been convicted and have had their sentences overturned and they have been released, yes. There are none from death row in California where a person has been shown not to have committed the crime. 0 out of 900 cases.
Thank you. Well, I appreciate the engagement. Again, I appreciate your service in the respective offices you serve and on behalf of victims. Thank you for being here today.
Could I very briefly address the deterrence studies?
Yes.
There are a whole set of studies, and there is a great controversy among people about methodology. And the question of whether the studies showing deterrence, how convincing that is something that people debate, and how convincing they need to be is something people debate. From my point of view, I think it is a basic principle of human behavior that if you change the cost of doing anything, there will be some reduction in the number of people who choose to do that. And as applied to criminal law, that's deterrence. So I think the claim made that the death penalty is somehow special, somehow different, that death penalty alone doesn't have a deterrent effect when other penalties do, I think that would require convincing proof. One thing we can say for sure from the studies is that there is really no significant evidence disproving deterrence. There are a significant number of studies finding a deterrent effect, and then there is this debate among academics as to whether those studies are convincing or not.
Thank you. Thank you, Mr. Chair.
If I
Thank you.
might address the question relative to
Sure.
the deterrent as far as killing a police officer, I don't have any statistical data, but what I do know anecdotally is that frontline police officers know that criminals fear the death penalty. The criminals know that killing a law enforcement officer is one of the fastest ways to get yourself involved in a capital murder case. And then there's a reason that virtually every law enforcement organization in the state has not only endorsed the death penalty reform measure and opposed the repeal of the death penalty, and that is because the death penalty for cop killers protects us.
Thank you. Again, I think we wouldn't have over 700 people on death row if they had considered the consequences of their actions at the time that they took them. But
Could I just weigh in? I'm not versed in the studies of deterrence or non-deterrence, but what I think everybody's missing, that's really not the issue. It's the issue of justice. And there are certain crimes that deserve the ultimate punishment as decided by 12 of their peers. And for those victims, it's about justice. Victims do not care about deterrence or non-deterrence. It is not hatred for them, but it is knowing that their crimes rose to a level that civilized society said that they deserve the ultimate justice. And so I would almost ask this panel not to really get hung up on the deterrence, non-deterrence. It is the importance of justice that should prevail.
thank you.
Mr. Anderson?
It strikes me that when we have these studies, I think we all can agree where the death penalty is actually used to the full extent, nobody whose life has been terminated has ever committed a future crime. So I think we all can agree that that is a deterrent if the person's executed. Could you, maybe somebody could speak to this, could you just briefly go through again the capital punishment? So if I'm in a heated argument and I shoot somebody, or I come home to find my spouse cheating, would these fall under capital punishment, or are we thinking about individuals that are serial killers? Are we talking about people that are cold and calculating with their killing, laying in wait, or been hired to kill? So, because I think there's a lot of confusion that capital punishment is across the board applied to everybody. So if you could go into that a little further, I'd appreciate it.
I can address a good part of that. The scenario that you described would never be eligible for capital punishment. That would be considered probably a second-degree murder. For a crime, for a murder to be eligible for capital punishment, it first and foremost must be first-degree murder, which requires the murder is willful, deliberate, and premeditated, or fall under some of California's other theories of murder, such as felony murder, lying in wait. Then, in addition to that, there has to be a special circumstance found true, and we have a panoply of special circumstances, a few of which have been found unconstitutional, but many of which would include multiple murders, conviction of prior murder, murder during the commission of rape, child molestation, torture. So there has to be the first-degree murder plus the special circumstance found true by a jury for that crime to be eligible for death. And then even when both of those are present, when the murder appears to be first degree and there are one or more special circumstances, because there are very frequently more than one present, the question then becomes whether a particular prosecutor's office even seeks death. And even where there is eligibility, death is actually sought in very few of those first degree murders with special circumstances.
Okay. Are there any other questions?
Yeah. You know, it strikes me that at the root of all this, it is a discussion of what justice means. It's interesting, I think, that victims are divided on that. And the give and take is really, I think, strikes at a very deep thing in every person. I am interested, however, in the practical application as well. in that it would seem to me there would be a great many more discussions of appeals and whatnot. I counted 22 special circumstances, possible special circumstances, and also the treatment of the habeas center. So what would be the costs of really looking at all those special circumstances and in this case with fewer appeals and a shortened timeline?
Well, there are a large number of special circumstances, and the number perhaps could be trimmed. In practice, though, I think the death penalty is being applied quite selectively. I did a study of a sample of cases, the cases decided by the California Supreme Court within a 2-year period, and counted which special circumstances were actually present in cases where the death penalty really was imposed. And I found that clearly the most common was simply killing more than one person. Multiple murder and prior conviction of murder accounted for the bulk or a majority of the cases. Although murder in the course of a robbery with nothing else is in theory a capital case, there was only one case in the whole sample that fit that description. So prosecutors are being selective in the cases in which they seek the death penalty. Juries are being selective in the cases in which they impose it. And I think the large number of special circumstances is not really the problem in practice that one might think just from reading the statute.
If I can reiterate that, I think that's very true. For example, murder by poison. I don't know that our county's ever charged someone with that special circuit. It just doesn't happen. Murder by a destructive device, that's a bomb. It just doesn't happen that often. Kent's correct that the vast majority would be murder of multiple people. But keep in mind, myself as well as every district attorney I know in the state, when we make a decision to seek the death penalty, we don't seek it because I think I would vote for the death penalty. Our standard is, do we believe 12 jurors, 12 members of the community, like Ms. Salerno talked about, would find that death was appropriate? So we don't sit in their place, but we try and think about that standard because we don't want to try cases just to try them, and we don't try and impose our own standard. And so that's why we seek it very infrequently. And even when we seek it, it's still up to the jury to decide whether to give it. So it is just sought so rarely.
And if I could add to that, the number of special circumstances, as the other speakers mentioned, is not really the issue. Some of the scenarios just rarely occur. Murder of a federal agent, knowing they're a federal agent, is a special circumstance under state law, which presumes that the state's going to be prosecuting someone who was murdered as a federal agent. It's happened one time in the state of California that I'm aware of. But that doesn't mean it shouldn't be available as a special circumstance should that scenario arise. Also, in my office, there are some special circumstances that just aren't used. The gang special circumstance is never filed alone. There are just too many gang murders in Los Angeles to seek death or consider it for the number of murders that would be eligible based on that alone. So we actually sort of skew our own statistics to our disadvantage by not filing that, because it doesn't enter into our committee's decision-making process and how many eligible cases they seek death for. And I think they're trying to change that. But the fact of the matter is, and I've run the statistics for my office, around 80% of all the cases in which we seek death include more than one special circumstance, and 80% of them include either multiple murders in the same case or a murder where the defendant also has prior convictions of murder. Killing a lot of people, killing a police officer, and killing children are really the top three things that are going to...
Did you ever consider in the initiative limiting the number of special circumstances if they're rarely used?
Well, no, because the point is they should be available. If a federal agent is murdered by a person who knows they're a federal agent, that special circumstance should be available even if it's only used once in 20 years.
Okay, thank you. Thank you. Now, is one of the reasons that a juror can be dismissed in a capital case if they said that they had a leaning or a belief against capital punishment?
Leaning? No. It has to be considerably stronger than that. the standard is set by the U.S. Supreme Court, and it's a higher hurdle than that. And it's basically that his beliefs are so strong that it would make them unable to do the weighing of aggravating and mitigating that the law requires.
And there would never be a preemptory challenge used by a prosecutor of a person?
Well, both sides have an equal number of peremptory challenges, and they both use them to eliminate the jurors that they believe would be prejudiced against their case. And so by winnowing both sides, you get a group that's more in the middle. That's the way the peremptory challenge system works.
Thank you. Thank you very much.
Are there any other members with any questions? No, I guess I have could be a question and maybe more of a statement before we take public comment. Really, the dilemma I think most of the voters are going to have is what I like to call the rule of one innocent person. On one hand, you have the opponents who basically say that if we have someone on death row, they're not able to go out and commit another crime. And for them to get out again and just really to kill one person is really heinous and it's something that this society should look at as being intolerable. Whether it's a law enforcement officer, individuals that would go to that extreme, we really need to look at that strongly and look at special circumstances. So I definitely can empathize with that and also the victims, because one innocent person that is killed in that, I think is just horrendous. While the proponents on the other side will tell you that one innocent person that is killed on death row is equally heinous. And if you go before not necessarily a jury of your peers, and the prosecutor's white, your defense attorney's white, the judge is white, the jury's white, and you're an African American, and you're sentenced to death because maybe the jury may be more prone to kill an African American, that's equally heinous and difficult. I think that's what ultimately, when this goes out to the public, they're going to weigh in what I call the extreme of worst case scenarios. They've got to weigh that. And I think it's going to be a very difficult decision for them. But it's something that we need to continue to grapple with and ultimately make we get a chance to make a decision on how we feel as a state and how we're going to move forward. I don't know if there's any compromise to that. We're going to hear more testimony in the afternoon on some other initiative. But hopefully you can see how difficult this is when you're trying to protect what I call the one innocent. It's just extremely difficult to do that.
And I think that's very true, and that's why I think that it's admirable the state of California, when they did the study of decades, that no innocent person has ever been executed in the state of California. And, the protections in place are so extensive, and it doesn't mean we couldn't make a mistake. I think everybody here, that'd be horrifying if any of us, no one supports that. But I think there are protections in place to make sure that doesn't happen. And the voters, knowing that is in place, still support the death penalty.
And we're not going back and forth, but I would submit that we probably don't have any evidence that an innocent person actually may have been put to death. Once someone's put to death, as some of my colleagues on here have said, they can no longer, one, commit another murder, but subsequently we're not going out and trying to prove that they're innocent after they've been put to death. So there's not a whole lot of energy either way to prove or disprove it. And so that's the challenge for what we're going to have to make a decision when we go to the polls on this. And so I want to thank everyone for testifying. I especially want to thank you for staying within the time limits. I will tell you, this has been a very good panel too. Your information was pointed to the, and I think you made your points very not only credible, but I can also too feel the passion that you have behind this. And so, on behalf of the committee, I want to thank you for testifying today. And did you?
I agree.
All right, thank you. And we'll now take public comment. So, depending on how many people we have.
Right. If people would come forward, we
1
have
minute.
20 minutes before we have to adjourn.
So we're going to do 1 minute
Leave
apiece,
the room.
because I think we're getting up to,
About 20.
well, is that it?
Let's see.